Hello, Assalamualaikum. My name is Muhammad Azhar Ahmad. Today I want to talk about Assignment 2 International Business Law. Okay, the topic is United Nations Convention on Contract for the International Sales of Goods. Okay, this is the definition of United Nations Convention on Contract for the International Sale of Goods, UNCCISG. It has been recognized as the most successful attempt to unify a broad area of commercial law at the international level. The Self-Executing Treaty aims to reduce obstacles to international trade, particularly those associated with choice of law issues, by creating even-handed and modern substantive rules governing the rights and obligations of parties to international sales contracts. At the time this is written, February 2009, the CISG has attracted more than 70 contracting states that account for well over two-thirds of international trade in goods, and that represent extraordinary economic, geographic, and cultural diversity. Okay, the CISG is a project of the United Nations Commission on International Trade Law, UNCITRAL, which in the early 1970s undertook to create a successor to two substantive international sales treaties, conventions relating to a uniform law on the formation of contracts for the international sales of goods, and the convention relating to a uniform law for the international sales of goods, ULIS, both of which were sponsored by the International Institute for the Unification of Private Law. The UNCISG governs sales contracts, especially in providing interpretation and gap-filling measures between parties in countries that are signatories of the convention. It was originally signed in 1980 and went into effect in 1988, and now has a total of 67 signatory countries. The UNCISG in an international context work much like the sales portion of the UCC, thus in domestic transaction, with the exception of a few important distinctions. Okay, number 2, the establishment of UNCCISG. Although the UNCISG and UCC are very similar, one difference is that the UNCISG requires the parties to specify the price of the goods involved in a transaction. Under the UCC, if the parties fail to specify the price, a reasonable price will be later determined. With the UNCISG, a contract without price will fail due to indefiniteness. The UNCISG and UCC diverge on the requirement of contract in writing. The UCC requires that if a contract for the sales of goods is more than 500, the contract must be in writing. Unless it is considered that there was indeed a contract, or if the goods have been accepted and payment made, the UNCISG, on the other hand, has no requirement for writing. Okay. Number 3, the importance of UNCCISG It is the fruit of many efforts to harmonize international trade laws and alleviate cross-border transactional difficulties. The CISG brings a common understanding to the negotiation table, and it is synthesis of the conceptual concept of common law and civil law. The subject matter of the CISG is limited. It only applies to goods and excluded services. The subject matter of the CISG is limited. It only applies to goods and excludes services. It has been stated under Article 32 of the CISG that the CISG does not apply to contracts in which the preponderant part of the obligation of the party who furnish the good consists in the supply of labor or other services. Such similar to the U.S. Uniform Commercial Code, hybrid contracts that mainly consist of service as their main obligation are not governed by the provision of the CISG. Okay, the goal of UNCITRAL was to create a convention that would attract increased protection in uniform international sales rules. The text of the CISG was finalized and approved in the 6 official languages of the United Nations at the United Nations Conference on Contract for the International Sales of Goods held in 1980 in Vienna. The CIS entered into force in 11 national contracts, and since that has steadily and continuously attacked a diverse group of adherents. Okay, number 4. The summary structure of CISG. Structure of the CISG. Part 1, Sparrow of Application and General Provision. Article number 1 until 13. And then Part 2, Formation of the Contract. Article 14 to 24. And then Part 3, Sale of Goods. Article 25 to until 88. General Provision, Obligation of Seller. Of Buyer, Obligation of Buyer. Right of seller, passing of risk, provision common to seller and buyer. Damage. Okay, part 4, final provision, article 89 to 101. Okay, moving on. Okay, take a look at part 1, sphere of application and general provision. Article 1 to 13. The CISG applies to contract of the sale of goods between parties whose place of business are in the different state when the state are contracting states. Okay, if given the significant number of contracting states, this is the usual part to the CISG applicability. The CISG also apply if the parties are situated in different countries which need not be contracting state, and the conflict law rules lead to the application of the law of contracting state. For example, a contract between Japanese trader and a Brazilian trader may contain a clause that arbitration will be in Sydney under Australian law, with the consequence that the CISG will apply. A number of states have declared that they will not be bound by this condition. The CISG is intended to apply to commercial goods and products only, with some limited exception. It does not apply to personal, family, or household goods, nor does it apply to auction, ship, aircraft, or intangible and services. The position of computer software is controversial and will depend upon various conditions and situations. Okay, moving on. Okay, The contains for Part 1. Importantly, parties to a contract may include or vary the application of the CISG. Interpretation of the CISG must consider the international character of the convention, the need for uniform application, and the need for good faith in international trade. Disputes over interpretation of the CISG are to be resolved by applying the general principle of the CISG, or where there are no such principles but the matters are governed by the CISG, a gap with the agent, by applying the rule of private international law. A key point of controversial is whether or not a contract requires a written memorial to be binding. It's a law for a sales to be oral or unsigned, but in some countries, contracts are not valid unless written. In many nations, however, contracts are accepted, and those states has no objection to signing, so states with a strict written requirement exercise the ability to exclude those articles relating to oral contract evident to sign. The size is not a complete calculation by its own definition. This gap must be filled in by the applicable national law under the jurisdiction of the Committee of Law rules applicable at the place of jurisdiction. Okay, moving on to part 2. Formation of contract, Article 14 to 24. Okay, an offer to contract must be addressed to a person, be sufficient definitely, that is describe the good quantity and price, and indicate an intention for the offerer to be bound and on acceptance. The, the CISG does not appear to recognize common law unilateral contract but subject to clear indication by the offerer. Treat any proposal not addressed to a specific person as only an invitation to make an offer. Where there is no explicit price or procedure to implicitly determine price, then the parties are assumed to have agreed upon a price based upon that generally charged at the time of the conclusion of the contract for such good and the comparable circumstances. Okay, part 2, formation of contract, Article 4024. An offer may be revoked provided the withdrawal reached the offered before or at the same time as the offer, or before the offeree has sent an exception. Some offer may not be revoked. For example, when the offer reasonably rely upon the offer has been irrevocable, the CISG requires a positive act to indicate action, silent or inactivity are not an exception. The CISG attempts to resolve the common situation where an offerer replies to an offer accept the original offer but attempt to change the condition. Okay, any change to the original condition is a rejection of the offer. It is a counter offer unless the modified term do not materially alter the term of the offer. Change to price, payment, quality, quantity, delivery, liability of the parties, and arbitration condition may all materially. Yeah. Okay, moving on. Article 24 to 88. Sales of goods, obligation of the seller, obligation of the buyer, passing of his obligation common to both buyer and seller. The CISG define the duty of the seller, setting the obvious as the seller must deliver the good, hand over any document relating to them, and transfer the property in the good acquired by the contract. Similarly, the duty of the buyer is to take all steps which could reasonably be expected to take delivery of the good and to pay for them. Okay, sales of good. The good must be of the quality, quantity, and description required by the contract, be suitably packaged or fit for purpose. The seller is obligated to deliver goods that are not subject to claim from a third party for infringement of industrial or intellectual property right in the state where the goods are not to be sold. The buyer is obligated to prompt examine the good and, subject to some allegation, must advise the seller of any lack of conformity several times and no later than with 2 years of action. As he described, when the risk passed from the seller to the buyer, but it has been observed that in practice most contracts define the seller delivery obligation quite precisely by adopting an assignment shipment term such as FOB and CIF. Okay, remedy of the buyers and seller depend upon the character of a breach of the contract. If the breach is fundamental, then the other party is substantially deprived of what is expected to receive under the contract, provided that an objective test shows that the breach could not have been foreseen, then the contract may be avoided and the aggrieved party may claim damage. Where part performance of the contract has occurred, then the performing party may recover any payment for a good supply. This contract will deal with the common law where there is generally no right to recover a good supply unless title has been written. Okay. For summary structure of Part 3. If the breach is not fundamental, the contract is not void and remedies may be sought, including claiming damage, express performance, and adjustment of price. Damage that may be awarded conform to be common law rules in Hadley and Paxson deals, but it has been argued the test of responsibility is slightly broader and consequently more generous to the aggrieved party. The CISG excludes a party from liability to a claim of damage where failure to perform is attributed to an independent beyond the party or third-party subcontractor control that could not have been reasonably expected, such as intervention, even might elsewhere be referred to a violation of the contract. The seller has to refund the price paid, then the seller must also pay interest to the buyer from the date of payment. Okay. The CISG issues a party vulnerability to a claim of damage where a failure to perform is independent beyond the party or third subcontractor that have been reasonably expert, such as even might otherwise be referred to as violation of the contract. Seller has to refund the price paid, then the seller must pay a surprise the buyer for the date of payment. It has been said the interest rate is based on the rate current in the seller's state. The obligation to pay interest but takers of the seller obligation to make restitution and not a buyer right to claim damage. This has been debated in a mirror of the seller obligation where a buyer has to return goods the buyer is accountable for any benefit received. For final provision, Article 1819 to 101. Article final provision include how and when the convention come into force, permitted reservation and declaration, and the application of the convention to international sales where both states concerned have the same or similar law on the subject. The Part 4 article, along with the preamble, are sometimes characterized as being addressed primarily to states, not to business people attempting to use the convention for international trade. They may, however, have a significant impact upon the CISG practical applicability, thus requiring careful scrutiny when determining each particular case.
Okay, that's all. Thank you.